Hi guys, it's Kathy. I hope you're doing well. We made it to Wednesday night. I do have to go pick up Anthony. He's not supposed to work Wednesdays, but restaurants don't live like the rest of us. They go by their own schedule. Tiffany's going to take over the stream when I have to leave. If I have to leave. Who knows what time he gets off. He works at a restaurant. I might be done with my stream by the time he gets off, but do not worry. We are way more prepared this time than we were last time. And court's going to continue, even if I'm not here. So the first clip we got, so it is a murder sentencing, but the mother asks for a very unique request. All right. We do listen to her talk about, her life with her son's gone. It doesn't take long, okay? And then she makes this unique request to this judge. Then we get to hear these prison phone calls. They're not the best quality. And they're going to explain them in detail after we listen to them. But we're going to get to hear the prison phone calls, which he does say a few offensive words in there. But anyway, we'll see what the judge does with this mother's request. I kind of like it and kind of don't like it. I'm torn. I think I like it more than I don't, though. I don't know.
Davis, 46D02-2407 MR3. Show Mr. Davis appears in person with counsel, Mr. Payne, State of Indiana, by Mr. Caviston. And we are here today for a sentencing. Is that correct?
It is, Judge.
And this is an argued sentencing after a jury trial, correct?
Correct.
All right. Let me first ask Mr. Davis, there was a pre-sentence investigation that was prepared in this matter. Did you get a chance to review that?
Yes, sir.
Are there any additions or corrections that need to be made, or is the information in that document accurate?
It's accurate.
Mr. Harris.
Your Honor, Mr. Taylor's mother, Superera, is here and she would like to make a statement.
You can come up here, ma'am.
Mm-hmm.
Okay. Tell me your name.
Donna Sue Barrera.
And you would like to make a statement?
Yes, please.
All right, I know it's hard, but try to wait until she makes the request before you react to the pull.
Go ahead. Go ahead. Is Donnell's parents here?
I do not know that.
Okay. First off, I just want to say thank you, Judge, and to the attorneys for seeking justice for my son, John, and to the defense attorneys as well for seeing to it that Donnell had a fair and just trial as well. And the jury isn't here, but I'm also grateful for the insights and the questions that they had during the case that really boosted up my confidence that it was a
Kelly, how did your doctor's appointment go?
good group of people that were looking out for both interests, both for Donnell's and for my son's. I'd like to start with my impact statement regarding my son's children, my grandchildren. He has 3 children, 2 boys and a girl. the impact that it had upon John's children when they learned that their daddy was gone and gone forever, had a big impact on them. Daxton presented in anger and is currently still in counseling for that. Kinsley, she presented with depression, and she too is still in counseling for that. They both ask about daddy from time to time, and they both say, I miss daddy. Malachi, the youngest one, wasn't born yet before John was killed, so he will never know.
Is Malachi the name of the person in Children of the Corn? Remember at the end, he wants you to, Malachi. He wants you to. Was it Malachi? Was that his name?
Oh, his daddy, he may recognize the name, but there won't be any personal relationship that Malachi can look back on. The flip side of the coin, Donnell, if you have children, is now they don't have a daddy either, and I can only imagine what they may be going through. A daddy is a very big, important piece of children's lives, and now they won't have theirs either, let alone the mother of your children will have to carry on now without the help and the guidance of a father and a mate, which makes it twice as sad in my heart for the children because of a choice that you made that could have been different and turned out differently. Your parents, I know what I'm going through with the loss of my son, and I'm sure that there is grief in your parents' hearts that symbolically they have lost their son. So I don't know if you'll be able to walk out in freedom after today. And that's very sad. For me, the impact that it's had on my life is tremendous. You may wonder why I'm the only family member of John's that is here today to represent him. I lost my daughter in a car accident, followed by John's death. And then my husband died 3 months after the murder of cancer. So I'm the only surviving member of my family. I do have grandchildren, and I love them dearly, but they cannot replace my own family. So I walk through the rest of my life without an immediate family.
Except your grandchildren.
John won't be able to see or meet Malachi. He won't be able to see his own children grow up, meet developmental skills, and who knows what path my grandchildren will take. He won't get to be a part of that. He won't see graduation. He won't get to see their weddings. He won't get to see and witness all of the important things that they do and accomplish in life. Because one decision destroyed that. I don't know if John's death has had an impact on you. I hope that there has been an impact within you, if not for how it's going to affect your life from here on out. But the stigma you will have to carry from now on. Opportunities may be restricted because of the choice you made, and that's sad. Very sad in my heart. I have depression and I'm in counseling. ever since John was killed. And I think I will be in counseling for quite a while because I've got so much that I have to deal with. So in closing, if it's...
Okay, here we go. We made it through. And now she's about to request something from the judge. I don't know. I don't know how I feel about it.
Permitted, sir, I'd like to suggest what I would like Donnell to do or have, whatever. But John's children now have a single parent, and she's struggling. So what I'd like to happen to Donnell is that he be kept healthy and strong, that 10% of his wages while he works in jail will go, 10% of his wages will go to each child every day, every week, until the last child is 26 years old. And then he will be released from that commitment. So when the oldest child is 26, he no longer has to pay 10% to that child. Second child is 26, he will not have to pay money for that. And when the last one is 26, he is released from his obligation. Why do I make that request? Because John is not alive and
Don't answer the yet. Don't wait. There's more.
present to support them financially. And worst of all, he isn't here to support them emotionally, physically, and spiritually. 10% is not going to do much of anything, but it will certainly help mom in raising the children and meeting their financial needs. And the last request that I have is that Donnell's wages will be garnished, and to me, 20% of his wages will go to me until the day that I die. John was supportive of me when he thought I wasn't doing very well. He was there for me financially. And so, because I don't have him anymore, that is my reason for requesting a little bit of support that John will not be able to help me out with in my rough time.
So I know, and I don't know what state it is, Idaho maybe? I don't know what state it is. They're trying to pass a law that if you kill a parent in a drunk driving accident, you have to pay child support. Makes sense to me. Now we can vote on what we think about her request. I'm okay with him having to pay for the kids, unless the mom gets remarried. But maybe not until they're 26, till they're 18, like a normal child support sort of deal. I don't know about 20% of his earnings going towards mom. Only because, okay, logistically, there has to be a different way to punish. Let's say he murdered 7 people. Well, then all 7 people's mothers would take 20%. That mathematically doesn't work out. And the kids, actually, the whole, if you kill the parent in the car, in a DUI crash, that won't work out either, because what if you have 6 DUIs? I mean, yeah, it's not normal child support, not at all, not by any means. But, like, logistically, it wouldn't, I don't think that would work. Like, maybe they could bump it down if you're, 10% of his total income can go to the victims and they split it evenly. That would work. Then if he has 100 victims, they all get what, $5 a month. But I don't think 10% per kid, 20% for the mother. I don't think mother deserves 20% of his income. It would be nice. My 3 kids, if I still got child support, I wouldn't complain. They're still very, 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 very freaking expensive. They are. But, okay, you can vote now. You can vote on what you think.
I just want Donnell to be healthy and strong, that he can get up and work and meet his commitments. Underlying reason is I don't want you to forget my son and what you did. I hope that it will deter you from making the same choice in the future with somebody else. Thank you.
Mr. Caveston.
Thank you, Your Honor. Your Honor, I also have, in this, listening to some jail calls between Mr. Davis and some of the people he was contacting, I do have a recording of a call that he placed on January 29th, shortly after the verdict.
So that we're about to hear the jail call. It's not awful long. It's not the easiest to hear, but you'll be able to hear it. You will be able to hear what he says. It's just not the easiest to understand. And then after the jail call, especially when the judge starts to speak at the end, he really pulls the jail call apart.
I'd like the court to hear.
Go get it for sure. I need you to look up. They got the station now. Hello.
Took you long enough.
Go get it for sure. I need you to look up. They got something on the door with the nigga that told on me. I need you to look up. Get on the IPOC website.
DOC website?
Yeah, they got to take me in here. I'm about to. Oh man, I'm on the head of it.
Yeah. They about to take you into the. They about to take you where?
And then with the nigga that told on me.
Baby.
Man, what you talking about?
What do you want me to look at?
What's his name? Jared Seaborn. J.E.
Hold on, I'm trying to find it. I'm trying to find the
I swear to God.
Last chance to vote. I'm going to end the poll in a few minutes.
What's his name? Okay, give me a minute. Get out for a second. I'll call you when I'm ready. Okay, last name what?
Last name is Seaborn. S-E-A-B-O-R-N.
First name?
J-E-R-R-O-D.
J-E-R-R what?
O-D.
Oh, Jared. Nothing came up.
That nigga locked up. Well, he got in the county and okay, try Angelita Mercado.
Angelito.
Mercado. N-E-R-C-A.
N-E-R.
C-A-D-O.
C-A-E-O.
C-A-D-O.
Oh, hold on. Angelito. All right, say the last name again.
M-E-R.
Are you saying M?
Mary, Edward, Rachel, Cat, Apple, Daniel, Octopus.
So I ended the poll. 20% say no. 40% say yes. Zach, Thank you so much. I appreciate you. I really do.
Okay. Nothing's coming up.
Man, how you spell Angelito?
Angelito.
But you got on the right website there, man. I know who affect this nigga in the joint.
Oh, I did it backwards. Hold on. Angelito. MER.
CAGO.
EO or DO?
Daniel Octopus.
Sorry, baby. There we go. What you want to know?
Where he at?
Miami Correctional?
He at Miami?
Mm-hmm.
What's
Hi,
his
Lama.
album?
12/7/28.
Lama, have you ever prunked? I don't know either. I'm just asking.
Mm-hmm.
On my kids, he not stepping foot back on that can and not done happening to him. I'll make shit shake. All right, I need to look up the other nigga now. To make sure you weren't looking hip hop bastard.
Okay. Last name?
Seaborn.
Oh, Seaborn. Jerrod.
Yep.
He ain't coming up.
They're going to say exactly what he's asking for in a moment. Don't worry. You're going to understand.
All right, he might not be returning. He might be in the town. What? That nigga in Miami? You in Vice Fortopolis? What? I'm about to show you some. Yeah, these niggas crazy. I'm ready to go get in the shower now. Anyway, you sure?
Anyway, I said you stupid.
I'm just saying, let this nigga be out control. It's all wood part, so.
You would think they wouldn't put him. You would think they would put him in suicide watch or some shit. Or like,
they taking you to the down. This is when we go to shower, but it's going to come up where it's bad being saved, basically. They blew it. They bring security like that on my mama, on my shoes. You're done, son. You're done.
he gonna shit on himself.
You're done. Oh, I'm about to have a ball. Anyway, what's up with doing Mr. Idiot, baby?
Your Honor, quite clearly, Mr. Davis is, in fact, one of the statements he made is I'll make sure he's shanked. And he's seeking to give retribution against Mr. Mercado, Mr. Seaborn, for testifying against him. So I just wanted the court to be hearing that. I have no other witnesses, Your Honor. If you'd like to hear argument from the state, or
I would.
very good. Your Honor, given the nature of this offense that you've certainly heard the details of, you've heard from Dr. Fesco's testimony, the overwhelming extreme violence that was put upon Mr. Taylor through the course of this long, prolonged beating that resulted in his death at the hands of Mr. Davis. That alone, frankly, the state would be asking for this full 65 years. But in looking at the pre-sentence investigation, Mr. Davis's criminal history is quite lengthy. He's only 30 years old. He has 8 pages, 37 referrals of juvenile history, 5 felony convictions for arson, 2 serious violent felons in possession of a firearm, criminal recklessness, and a battery, 37 conduct violations in the Department of Corrections. Of course, he was in the Department of Corrections during when this took place, serving his sentence. All of these things that took place, that his history, again, the absolute horrific beating that John Taylor sustained through the course of this, to the point where defendants were crying during interviews and on a witness stand through the course of this trial. It's staggering.
The people who were crying on the stand were the two inmates this guy was looking for. So while he was in jail, he wanted her to look up where these two are located so that he can retaliate, because they were witnesses and they told what happened in court. Felons. I mean, I got to assume they're felons because he was in prison when this happened. This happened in prison. These were two other felons who were in prison with him, crying on the witness stand when they're saying what this man did to this other man. Crying.
What to think of what people that saw it experienced, let alone what Mr. Taylor experienced before he was killed. The state is asking for the full 65-year sentence fully executed. Obviously, at that point, no probation. There's this audio, of course, shows very little remorse for this. In fact, it's just seeking retribution. So the state is certainly comfortable asking, and we feel that 65 years fully executed in the Department of Corrections for Mr. Taylor's murder is warranted, and that's what we asked for. Thank you.
Any authority or anything you want to say to the court about mom's request for restitution in the manner she requested it? I've not seen that before like that. So do you have any authority that would allow the court to do what she's requesting?
I don't know that there is or isn't in that sense. I know the restitution statutes are fairly restricted to actual damages based on perhaps it can be extended to things like funeral costs and things. I didn't see anything that indicated that it was permissible, but I don't know that the restitution says it's not, but I understand that there's a lot of limitations to that.
This is a sentencing after he was found guilty of murder in a jury trial. So there's no bond. Nope. There's a sentencing. This is when he goes to jail.
All right, and certainly what Ms. Burr is asking for is probably more likely suited for a civil arena than for in a criminal case. But certainly, Ms. Burr is asking for that. But I will concede to the court that there's probably unlikely the court can approve that.
Okay, but he did say, and he's a lawyer, so we have to assume he might know a little bit. He did say that her request is better for a civil arena, which means it might, and I use that term strongly, might be possible that this mom can go in front of a civil judge and get 20% of his wages until she dies, regardless of how much it is, even if it's $5, $10.
Because usually when I'm dealing with a restitution, I have to put a sum certain in there based on something that's been lost, not just payment of a percentage. And if you had some authority that would allow me to do that, I was interested in hearing about it.
Unfortunately, I don't. And Ms. Burr had asked, had talked to me about that previously. I had made efforts to see if that's possible, and we had discussed that it may not be possible, but I certainly empathize with her request, and it does request, but it is perhaps more suited to a civil arena than a criminal restitution. And so I will concede that point about the likelihood of the court being allowed to ask or order that.
Okay. Mr. Payne.
Judge, I do not believe Donnell wants to make an allocution, but could the court confirm it's on the record?
Sure. Mr. Davis, is there anything you wanted to say?
Not at all.
Mr. Payne?
Judge, as I prepare for sentencing, I have a list of statutory and not statutory mitigators that I always reference. And frankly, the only one I was able to identify was the defendant's remorse. That's evident through probation's statement within the PSI that he was remorseful. It's evident through his attached statement that, I can't remember the exact words, basically, this shouldn't have happened. So I'd ask the court to find remorse as a significant mitigator. More of a big picture, Judge. I take nothing away from the jury's verdict, taking nothing away from their finding that this was an intentional act. I could also, consistent with that, see that this wasn't necessarily intended from a layperson's perspective. We're all well aware of the facts that led up to this, the phone altercation, the prison environment. So this whole big picture, I believe his statements suggest that whatever happened was something that happened that got out of hand. He didn't set out that day to kill anybody. He didn't set out that moment to kill anybody. It was something that got out of hand. Maybe over the course of
It's a bunch of bull. We see prison shows. We know what happened.
a half hour or an hour, but it was something that was premeditated. Maximum sentences are for the worst of the worst. In my view, maximum sentences are not for someone that's truly remorseful. Maximum sentences are not for someone who sort of got caught up in a situation. Judge, I believe he's 30 years old, or about 30 years old right now. Any sentence. This is not a minimum sentence case. I know that. This is not an advisory sentence case. I know that too. Whatever the court does, he's going to be an old man if he ever gets out. I would ask the court to do something less than maximum.
Yeah, okay. Well, if he got the 65 years, it's day for day credit, isn't it? No, wait. He has a very long history, which means there's aggravators for this, which means he doesn't get day for day. He lost that. So instead of 65 years, he'll get what? 48 years.
Give him more of a chance to see some light. He has some good in him when he's an old man, Judge, I expect.
So he'll be in his 70s when he gets out.
Anything else from the state?
Your Honor, I think this phone call counters the remorse known in the statements that we're interested in retribution than it is that he is in remorse to the victim. And again, I think the aggravators being that the absolute extreme severity of the violence inflicted upon Mr. Taylor warrants it, as well as the criminal history. Thank you.
Hi, Anna.
Thank you. Mr.
I think he went to trial because he knew he was getting... the judge was going to give him 65 years if he took a plea. So at that point, you have nothing at all to lose to go to trial.
Davis, it took a long time going through your pre-sentence investigation because it's kind of lengthy with all of your history. And counsel knows when I go through these and I look at these types of crimes and these types of sentences, I don't take any pleasure in any of it. I don't take any pleasure in Mr. Taylor's death. I don't take any pleasure in having to give you a sentence because you've put me in a position and the jury has made their decision where I have to do my job. And when I look through your history, I see a pretty troubled history. And I wonder where that could have turned around. It's 8 pages of history. A lot of it when you're a juvenile, because you're a young man now, you're only 30 years old. And I wish I could give the restitution that mom is asking for. I just don't know that I have a legal way to do that. And Mr. Payne, I didn't hear from you on that, if that's even something that's possible or not. So
my sense was that the court didn't need to hear from me. My position is that I think it has to be a determined amount. I don't think it would allow to have a percentage of any future earnings, not knowing what those future earnings are. So while it's well taken, her request, I'm empathetic to that. It's within the court's ability to do that.
Well, it's the first time I've had that request, and I appreciate that, Mr. Payne. And Mom, for your information, I think it's a really insightful and a pretty amazing request because it would do exactly what you want, and that's for Mr. Davis to have to think about your son every day because some of his pay would be going out every time. But I don't think the way the current law is set up that I have the ability to do that. Even a judgment in a civil case would have to be entered of some kind of some certain. And I can't see any way to do that. I was trying to research as you were talking while I was still paying attention to you, if that's possible. I couldn't find anything. So I'm not going to enter the request for the restitution, although I really think that was a very insightful request. That's the first time I've seen that. Mr. Davis, as far as your aggravators and mitigators, I agree with Mr. Payne. When I looked at the pre-sentence investigation, the only slight mitigator I could find was some bit of remorse that was in there, and that was more of almost like an excuse, like it's something that got out of hand, or I wish it would have never happened. But when I balance that against the aggravators, and your criminal history is an extreme aggravator, just looking at all of that, the level of violence in the facts presented in this case is an aggravator. I think the phone calls to try to find out where the folks that testified are housed kind of erases some of that remorse that you showed when you filled out this. And I understand people have some remorseful thoughts, and then they get angry and have some angry thoughts as well when you're processing this whole thing. But I think the mitigators are completely outweighed by the aggravators here, which are the extreme violence. I think the criminal history itself far outweighs any bit of remorse that's there. So while I'm going to make a finding that you showed a small amount of remorse, I think that remorse has been erased when I listened to those phone calls. I'm going to sentence you to 65
It was, never mind, don't.
years into the Department of Correction. That's the maximum amount that I'm allowed to by law. You have 30 days to appeal that sentence, and Mr. Payne, the Public Defender's Office, will remain in place if Mr. Davis wants to file that appeal, which I'm sure that will happen since this was a jury trial and a murder case. So the Public Defender's Office will remain representing you, Mr. Davis. You have to file that notice of appeal within 30 days of today's date, and that'll start that process. Mr. Davis, do you have any questions?
Not at all.
Credit time, Judge?
Yeah, I don't know what the credit time is because I can't remember. He started out in prison with this and then he came to jail. So credit time, I think, would start when he was in jail.
Yes, which was, I don't have the exact, it's, actually I do, it's 520 actual days, which began on 9/28/24, 520 as of today. And I think that's 173 credit.
I believe it's 926, the 24, but yes, 520 days.
520 days?
No, I'm sorry. So that was from the effective date of the previous sentencing date of 227 or 227. So there's an additional 14 actual days. But yes, I would agree that 926 of 24 is when he was released from the Department of Corrections and started serving on this hold for this case.
So, and that was how many days then? Because
I'm sorry, Judge. So
this is my pet peeve all the time.
And yeah, so it's 534 plus an additional 3 days of good time credit. So 537 days is my calculation there, Judge.
What did you come up with, Mr. Payne?
534 plus 178.
534 plus?
178.
Oh, it's actual days. Forgive me. So 534 actual. Yes, I'm sorry. I misread that.
Plus 178. Okay. And you agree with that, Mr. Caveston?
I do, Your Honor.
All right. And Mr. Davis, you agree that you finished serving your other term in prison on or about September 26, 2024. All right. So we'll give you 534 actual days plus 178 good time days for credit. And we will get that in the sentencing order. On the request for restitution, Mom, I'm sorry, I have to deny that because I don't know how I would be able to answer that, but I do appreciate that. Anything else, Mr. Payne?
No, thank you, Judge.
Staff?
No, Your Honor. Thank you.
Good luck, Mr. Davis. Have a good day.
All right, let's go to Judge Fish. We don't see enough of Judge Fish. Okay, we do. But Hi, Judge Fish.
Ready? Good
Yep.
afternoon. This is
We're ready.
64D052411PL 11879, Greg Schaefer versus M7 Excavating LLC. Tom's, how do you pronounce it? Zeph. It's easy as it looks. Rick Moore and others. Looks like I have Mr. Schaefer in court in person and pro se. I have, you're not Mr. Sorden.
I'm Mr. Seville, Your Honor.
Yeah, Seville, there you go. In court for the defendants. We're set today on a 41E. Is that right?
Yes, Your
All right, how would you like to proceed?
Honor. Yes, Your Honor.
Your Honor, may I just, one question for the court?
Uh,
Well, it's in reference to sequence here. Because-
okay,
Okay, on January 16th, Mr. Schwarden requested the court, if you will, to substitute counsel, which is Mr. Seville here, but I don't believe there's been any official ruling on that. And I'm just expecting the record obviously to be correct, that has been accepted, and Mr. Seville has a right to represent the parties that are at cause here. And the fact of the matter is, I don't believe there's been any ruling on that.
Did we already see this? I feels like we already saw this. Did we already see this? I've watched it a couple times because I edited it. But did we already see it together?
Do you see that on January 15th, 2026? Notice of substitute of counsel is filed?
I do. Have you entered an appearance yet?
I have, Your Honor. It was included with our substitution counsel, I believe.
We already saw it. I know we already saw it. I know it. Thank you, Eileen. We already saw it. So I'm going to go to a different Judge Fish. I'm going to go to a Judge Fish who's talking to a pro se.
Cause number is
There we go.
64D012602F61252. Defendant appears in court in person and without counsel, State of Indiana by Gary Garman.
Morning, Mr. Reyes.
Morning, Judge. Have one.
First, I'm required to advise you of your various rights in this matter. You have the right to hire an attorney to represent you. You have the right to have an attorney appointed to represent you if you cannot afford an attorney. You have the right to a public and speedy trial by jury, and you have the right against self-incrimination. That means you cannot be forced to make any statement or testify against yourself at any hearing or trial held in this matter. Do you understand those rights as I've just gone through them?
I do, sir. Yes.
You've been charged here with one count, unlawful possession or use of a legend drug, a level 6 felony. The cause states that on or about February 3rd, 2026 in Porter County, you did knowingly or intentionally possess or use 23 pills of diclofenac, 18 pills of escitalopram, 3 pills of
Notice that, guys.
Zyprexa, and 1
Notice how the judge starts talking about drugs and Bill shows up. Hi, Bill. I enjoyed your stream today.
pill of meloxicam, 4 pills of cyclob or something of preen, and 1 pill of vardenafil hydrochloride, all legend drugs, contrary
Okay.
to statute.
I don't know what legend drugs mean. But, however, some of those drugs were not bad. Meloxicam, I mean, it's like ibuprofen, a little bit better than ibuprofen. It's not like, so I don't know what all those drugs mean. I don't know how many of those drugs were really drugs instead of medications.
You understand the allegations in count 1.
Yes.
It's charged as a level 6 felony, which carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. You understand that possible penalty.
Yes.
As required by statute, the court will enter a preliminary plea of not guilty for you on count 1. Do you plan to hire a lawyer in this case?
I cannot afford one, no.
Are you asking me to see whether you qualify for the public defender, or do you plan to proceed by yourself and without counsel?
I guess I could proceed by myself without counsel.
You're going to carry on in the case pro se
Yes.
and without counsel?
Yes.
All right. Well, I'll set a Feretta hearing for you where you need to come and we'll have a hearing about your ability to proceed on your own and without counsel. Make sure you have a knowing and voluntary understanding and that you knowingly and voluntarily waive your right to counsel. I'm not really sure, State, what the next Thursday morning looks like, but I'm going to squeeze this in next Thursday morning, March 12th at 8:30. There's only one video on there now, but I think it came off too. So I need you to hang out for a second. Can you print our pro se waiver right now? I don't know if you could or not. We'll give you our pro se waiver form. You take a look at that, digest it a little bit, and then after I'm done with my in custody call next Thursday morning, we'll go through the pro se form and we can see if you are capable of representing yourself and make a knowing and voluntary waiver of your right to counsel. Okay?
Yes, Your Honor. I thought it was gonna be taken care of today, though. I didn't know I had to come back out here. I mean, we don't live too close to here.
Well, I can go through the Ferretta right now if you want me to.
I mean,
But I'm going to print this form out first. You have some time, Mr. Prosecutor?
I do, Your Honor.
Let's
I
go
love
through a
Ferettas.
Ferretta real quick
I
then.
love them. They're a
When I
little
say
long.
quick, it's still going to take half an hour.
no, that's okay.
7 minutes. 7 more minutes.
Yeah. Avery, what's your last name? Pushka. I put a bench warrant for you, but I took it under advisement. I set your hearing for next Friday at 10 a.m. If you're late for court again, I'll put you in jail. You understand that? Oh, I bet it won't. We'll see you next Friday morning. All right.
Oof. Judge, before we start this Ferretta hearing, do you guys remember? Oh, for crying out loud. Separate views. I hate when it splits. Anyway, do you guys remember? You guys remember the pro se with the policemen in tear-off poison uniforms, lizard faces? He was suing Massachusetts and Connecticut and a whole bunch of cities in those, and the police officers. It was crazy. It was the bleep, 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 bleepity, bleep, bleep. Do you guys remember that, that hearing? Because I don't know if you remember, but there was a lot of dumpster fires in that. We put up, we made a lot of dumpster fire jokes in that stream. It was pretty good. It was probably one of the best streams that we've had on this channel, pretty much so. Bill makes these. Can you see? They're little desktop dumpsters. Are they not the cutest things ever? I just think, I mean, listen, we don't want to set them on fire, but we could add our own little fire on top out of cardboard or something, and we can store things in them. And desktop dumpster. Do not dump, anything in there that you don't want to keep forever. But look at that. Bill makes these and sells these. Are they not cute? He makes a whole bunch of stuff and sells a whole bunch of stuff, for real. I just picked that. Look at that. Look at that heart box. I need to make it bigger. Oops. I'm so dumb. Oh, the black one. Look at that. Look. How cute are they? Anyway. I want to put his link in here. Oh, never mind. Look at him. If you guys are crafty and need stuff for your cricket, look at that. Right there for your cricket stuff. Or a dumpster to remind you of court vibes. Then you should check this out because he has all kinds of stuff. Extra rings for a tape tower. Washi tape holders. For very crafty people, you know, you can hide your weed in there. You can. The black heart one is my favorite of the hearts. The dumpster is my favorite of all of them. This is page 2. I don't know why, but it is. But that's where you can see it. Hi, Judge Fish. Remember us? Keep going. You can continue now, Judge.
Here's a note for you if you need it, so you can be reminded of the time.
$51 minutes, 38 seconds.
Mr. Reyes, please raise your hand to be sworn. You swear affirm under penalty of perjury to tell the whole truth and nothing but the truth.
Yes, Your Honor.
Okay, thank you. Are you currently under the influence of any alcohol or drugs, sir?
No,
Okay. And do you have any mental health concern I should be aware of?
no.
All right. You don't have a trial set in this case, but you've told me that you plan to represent yourself pro se in this matter. Is that correct?
Correct.
And you understand that you have the right to represent yourself pro se, correct?
Correct.
And then if you don't want to do that, at any time, you can have court-appointed counsel provided for you if you can't afford an attorney. You understand that?
Correct. Yes.
Okay. Do you understand that there may be any number of defenses that apply to your case which an attorney's trained to know?
Yes.
All right. And I've explained to you that if you're convicted of your offense, that you're facing a penalty of up to 6 months, from 6 months to 2.5 years in prison. You understand that?
Yes, Your Honor.
You realize there are factors the court can consider when increasing your sentence within that range or decreasing your sentence within that range.
Yes.
And that those are factors that an attorney would know the most about.
Yes.
Okay. They're specially trained to know that kind of stuff. You understand that?
Yeah, I do.
Okay. You understand that lawyers have developed certain skills to assist you in presenting a defense to the charge.
Yes.
And you know that if you don't have a lawyer and you decide to represent yourself and things turn out poorly, you won't be able to complain that you weren't an effective attorney in your own defense.
Correct.
Okay. You understand you have a right to decide against having an attorney, and you're aware that deciding to not have an attorney can turn out to be a very bad decision.
Yes.
Okay. And you understand that experienced lawyers almost always decide to be represented by another lawyer in a criminal case.
Correct.
Okay. Before you appear at trial without an attorney, I want to ask you a couple more questions. Tell me about what skills, abilities, or knowledge you have that would be helpful to you in presenting yourself and representing yourself in this court proceeding.
I make a delicious cake roll. Does that help?
Sir.
No?
No.
Looks like I see like 22 pages of criminal history here. I'm not sure what you've been involved with. Have you ever been involved in the criminal justice system before?
No, I have not.
No?
Yeah.
Never been to court before?
I've been for traffic and for child support.
Okay.
Okay. Yeah.
Ever been to a jury trial before?
No.
Ever do any study of criminal law?
No, I have not.
Do you have any, well, let me ask you, how much education have you completed?
High school.
You have a diploma or GED?
Yeah, diploma.
Okay. Any college at all?
None.
Any trade school at all?
Painters Union.
Okay. Are you a painter now?
Yes.
In your activity as a painter, do you interact with people? Or are you like on the sales side or on the labor side?
Both sides.
Okay. So you have the opportunity to interact with people on occasion?
Yes.
Think you have a way with people and ability to read them and work with them?
Oh, definitely. Yes.
So if that jury box was halfway full of people, you think you'd be able to talk with them and make an argument to them, make a speech to them?
Yeah, I think so.
Think you'd be able to question a witness that was on this witness stand with these people watching you and with a room full of people back behind you here?
Probably not. So.
Good at public speaking?
No.
Okay. You know that there won't be any promises or suggestions from anyone that you'll receive special treatment or a milder sentence if you represent yourself?
Yes.
Okay. And nobody's threatening you or anyone else that you'll be harmed or disadvantaged if you represent yourself?
No, Your Honor.
Okay. And with all this that I've just gone through with you, you still want to represent yourself in this case?
I feel like I have a strong case. I have my medical records here. I mean, on my, this is the reason I was arrested.
Yeah, please don't talk about the facts and circumstances of the case right now.
Okay, yes.
Right? This isn't the appropriate time to do that. I just want to make sure that if you really don't want to have a lawyer, you're making a knowing and voluntary waiver of your right to counsel.
If I don't have a lawyer, would we get this over with today?
No.
No, we still have to come back?
Yeah, I mean.
Okay, so
That's
then I will take a state's attorney.
Please raise your hand. Well, you're already sworn in. What do you do for a living? You're a painter?
Yes.
How much money do you make doing that?
I'm just living enough to get by.
Well, how much is that, sir?
Probably about $1,000 a week.
You do about $1,000 a week?
Yeah.
And is that after taxes?
That was before tax.
So how much is your take home?
About 800.
Okay. And where do you live?
We live in Indian Head Park. It is in Illinois.
Okay. And are you buying or renting your home?
We rent.
How much is your rent?
To $2,900.
Okay, so his rent is $2,900 and he makes $800 a week. Okay. Okay.
Does your who do you live with?
My wife.
Does your wife work?
She does.
She's probably a
How much does she
doctor or a
earn?
lawyer.
She's a bartender. I'm not sure
She's
how
a
much she
bartender.
earns.
She earns a
She's here
lot.
right now, though.
I'm not gonna ask her if you don't know how much she earns. How long y'all been married?
We are engaged for 3 years.
So you're not married.
No, we not.
That changes things a little bit. So it's just your fiance?
Yes.
So before you say anything, it is hard to know how much your partner earns if they're a bartender. That would be a very difficult question to ask because who knows? Some nights it might be $20. Some nights it might be $300. So like average it. How do you average that? How?
Do y'all have any kids?
Together, no.
Do you have any kids who reside in the home?
Yes.
How many?
6.
Are you on any form of public assistance?
Yes.
State insurance?
State.
Food stamps?
Yes.
I'll find you're indigent. You qualify for the services of the public defender. I'll appoint the Porter County Public Defender Service to represent you.
Judge Fish, I'm not trying to tell you how to do your job because all of that was very interesting to hear. But if you lead with that question from now on, this would go much faster.
If you lived in Indiana, you wouldn't be indigent. How does that make you feel?
Mm-hmm.
True story. I set you up for a couple hearings. The first one's called an omnibus hearing. That'll be on May the 1st at 9 a.m. Second one's called a pretrial conference. That'll be on June the 5th at 9 a.m. You're ordered to appear for both of those hearings. We'll give you a note.
Thank you.
On here as well is the public defender's information, Steve Pribble. You need to contact him today.
Okay. I
Yeah.
will.
And
Thank you.
take your bags of pills and things so you can show him that.
Show him as well. Okay.
Yeah, he's not going to meet with you today,
Take
but
your
you can
bags
get on
of
his calendar.
pills.
Understood.
All right. Anything further, State?
Officer,
No, Your Honor. Thank you.
All right, we're adjourned.
the judge
Thank you,
told
Honor.
me
Good
to
day, sir.
take my bags
Safe
of
travels.
pills. That's why I have a bag of pills with me, officer. The judge told me I had to, officer. You don't understand. I'm following a court order. And if you arrest me for these pills, you're going to jail. I'm gonna get the FBI. Speaking of, this is longer. If you saw this on court disorder, this is the full one. This is a little longer. You see a little more. Actually, I'm going to do this one first. Again, if you saw this on court disorder, it's a little longer. We hear more because you guys deserve all of it.
And I don't want to see you go to hell. I don't want to see you in trouble by God for wronging me, that's all. Because I obey his commandments and everybody else should too.
There's been 2 evaluations filed, one February 11, 2026, and one sometime ago, November 17, 2025. And I wanted to raise this with both the attorneys and then determine where we go from here.
Wait. This is the court disorder one. This is the short one. This one is the one with everything. Sorry,
Good evening, ma'am.
clicked the wrong button.
This is 50-03-2501 F53, State of Indiana v. Naomi Gaff. She's with us in court in person. You can have a seat there, ma'am. And she's, as I mentioned, with us in court in person, now seated. Her attorney, Mr. Ariano, is with us in court in person, and the state's here by Chief Deputy Prosecuting Attorney Nicholas Langowski. We are scheduled for a competency hearing in this case, and there's been 2 evaluations filed, one February 11, 2026, and one sometime ago, November 17, 2025. And I wanted to raise this with both the attorneys and then determine where we go from here. I know we were scheduled today for the competency hearing for the court to determine Ms. Gaff's competency to stand trial. And were there other forms of evidence that the state was going to be presenting today?
No, Your Honor.
Was there any form of evidence that you were going to be presenting, Mr. Ariano?
No, Your Honor.
So essentially it'd be left to the court to accept those 2 evaluations as evidence determining competency, which leads to then my concern / question for the attorneys. They are split in their recommendation. One, finding Ms. Gaff competent to stand trial. One, finding her not competent to stand trial. And so I would be left with either.
So I have to pause it here because when we talk about competency hearings and things like that, we normally have a mindset of like crazy mental disorder. But competency to stand trial really is only, do you understand the court process? Do you understand the job of a lawyer? Do you understand the job of a jury? Do you understand what you're charged with? Do you understand the possible penalties of what you're charged with? It really has nothing to do if you're crazy or not. So we see competency issues being raised with people who have, like Florida guy mental disorders. But it's really not about that at all. We should see a lot more people get held for competency issues when they're telling the judge that their lawyer isn't putting forth the right motions and things like that. Those people should be held for competency because they do not understand the court process and what's going on, and that's all they care about for competency. So try to remember that when you're listening to this. It's not about if she's crazy. The court doesn't care if she's crazy.
2 paths. One
I'm not saying
is ordering a 3rd evaluation to aid the court in making this determination. Or second, the other option would be to accept both of those and then hear the arguments on both of those, and the court would weigh the evidence from both of those evaluations and make a determination as to the competency based on those 2. I am agnostic on which one to take, but I think that's where we sit currently as it relates to these recommendations.
The hiccup in the file that he has provided.
Hold on, Ms. Gaff. Hold on. Yeah, it wasn't necessarily a question. I was just offering this to the attorneys of kind of where we sit right now. What's the state's position in terms of moving forward?
No, Sophie. I worked at a comedy club when I was 19. When I was 19. I worked at a comedy club, okay? So on the weekend, like Saturday, we had the comedy show. Or Fridays. Friday was the comedy show. But then every other night of the week, there was no comedy show. We had karaoke, we had the male strippers, and other just bar nights and sports and things like that. But specifically, when I worked as the bartender for karaoke, I would some nights make $20, $40. But when I tended bar for the male strippers, oh my gosh, I would go home with pockets full of cash. And you would think I wouldn't because I was female. But those women were just happy. Unbelievably, unbearably happy. And when they were happy, they wanted everybody to be happy. They were just wonderful, wonderful, wonderful crowd. Every single time the strippers came in, the room was just amazing to be in. It just was, I'm serious. They were just all happy. It was just everybody happy all night long.
Are you wanting me to determine the competency based on the 2 evaluations or a third one?
Your Honor, I don't know that I can confidently request that you determine competency at this juncture based on the conflicting reports, given I've had very limited interactions with the defendant, so I don't know the ins and outs or the more intimate details as Mr. Ariano may have. I can just provide what I know from past cases. In past cases, there have been times where you have determined the competency based on your observations from previous hearings. There have been times where the court has ordered the third report. So ultimately, I would leave it to your discretion and be fine with whatever you decide in terms of determining the competency based on the conflicting reports or ordering a third.
What's your position, Mr.
Yes, Your Honor. Now, first, I obviously know, having spoken to Ms. Gaff, she would like to get past this issue as soon as possible. And I certainly understand or appreciate her point. I'm not a psychologist, but I can say that when we are speaking, Ms. Gaff appears lucid. In fact, we've even discussed some legal things. But then there are some moments where maybe the thinking or the thought process might perhaps be a little disjointed. And I know that that is one of some of the things that are noted by the by the medical professionals that conducted these evaluations, on top of the fact that they both seemingly diagnosed or indicated that she appeared to be suffering of an active mental illness. And the conflicting determinations on the competency in my position, I think I have to agree with Mr. Langowski that a third one would be necessary at least because they would also be over a wider period of time. And again, there are some differences or shortcomings in terms of the actual thought process is that make it conflicting for me to express my 100% support or full support that Ms. Gaff would be able to stand trial and fully understand the nature of the proceedings or of what was going on, because she does know a lot and she will be able to have some conversations, but I think there are some serious breakdowns.
It's when I talk about God, angels, and stuff like that people find a conflict of interest. And I'm about doing the right thing. I obey God's commandments every single day. I worship God every single day. There's nothing mentally incompetent doing that, obeying God and his commandments. I'm not breaking the law in any way, shape, or form, but people want to find me mentally incompetent every time I talk about God and angels, and I don't understand why.
Thank you, Ms. Gapp. One point that I wanted to make, and you raise a solid argument there about the time frame of these evaluations. They were over a series of months, and this potential third one would be over a further series of months. And so there'd be a greater time span that someone would be interacting with Ms. Gapp. And I also want to note, both for you, Ms. Gaff, but also in the record here, you mentioned, Mr. Ariano, that she wants to get this matter or get this situation behind her, and I can appreciate that. Where I see a lot of individuals conflate the constitutional requirement for a speedy trial, Criminal Rule 4 in Indiana, and then the intervening issue of capacity to stand trial. And a lot of times those three things get placed in the same category. And I want everyone in the record to be very clear is that this competency to stand trial is in an entirely separate realm, because the justice system is built on the idea that the individual understands and knows what is occurring in their case and able to assist in their defense. And so it's not necessarily that you have the right to a speedy trial and the right to be competent in your case. Competency is a priori from speedy trial, meaning it comes before and is more important at certain times. Because if you are not competent and we provide a speedy trial, well, our system still has failed because it has adjudicated a case against someone who does not understand what
the system failed when the officer tried me for charges I didn't commit. The lady lied on my name.
We're not asking about the facts of the case, Ms. Gaff. And there's really no question before you. I'm just trying to make the record clear of why and what I believe about this case. And I'm not making any statements, as you've heard. None of the statements have come up about the facts of this case or the evidence in this case. And so I appreciate your input here, but really strongly encourage you not to talk about the facts of the case.
I don't want to see you in trouble by God for wronging me, that's all. Because I obey his commandments and everybody else should too. And I don't want to see you go to hell. So I'm trying to help you all do the right thing in God's eyes. And that lady lied on my name.
I will also note for the record that at all the hearings that Ms. Gaff has attended, she hasn't had a lot of direct input because there have been status hearings. They've been initial hearings where the questions were very yes or no in nature, and there really hasn't been much input, nor does the court have personal knowledge, meaning I don't know Ms. Gaff from before. I have no knowledge of who she is, about her history at all. And so to Mr. Langowski's point and to your point, Mr. Ariano, I'm really left with what I see in these reports, and the reports are conflicting in nature. And so I don't really know what else the court has observed that would support a competency determination positively or negatively. And what I mean by that, Ms. Gaff, is you haven't necessarily said enough at any of these times for me to realize that there is a genuine capacity issue, competency to stand trial, that is. And so, I generally agree that a third evaluation is going to be beneficial because that will at least shed light on the time, another opinion from someone else that is skilled and trained in this area. And then the court can take up the issue of competency to stand trial after that third evaluation comes through. Now, while this competency issue is arising, there is still the stay in the proceedings in the sense that the CR4 time is not accruing, which largely gets to my point about the competency is coming before the speedy trial issue. And so what I'll just tell you, Ms. Gaff, is that you've been very responsive to having the evaluations performed. And so I genuinely appreciate that because it allows us to have a better idea of what is your perspective in this case as it relates to Mr. Ariano's role, the role of the court, the role of the judge, the role of the jury, the evidence in the case. And so there will be one more evaluator that is in contact with you. Same goes for you, Mr. Ariano. I'll get the evaluator appointed, and then they will be contacting you and your client to have the evaluation scheduled. And I just want to let you know there'll be...
Don't worry, she has more to say.
One more at this point.
Is there,
as you've done before, just follow through with that one more evaluation as you did previously. What was your question, ma'am?
Is there a way you could please have the lady who lied on my name assisted with maybe interrogating her as to why she lied in the first place?
Well,
and to see if she can get...
Ms. Gaff, I'm going to interject here again. This is largely about the facts of the case, and it's not necessarily the proceeding today for us to do that.
Okay.
You do have the right to confront and cross-examine the witnesses, and Mr. Ariano is keenly aware of that. And so, yes, there will be an opportunity to confront, as your perspective is pointing out, irregularities or things that you don't believe to be true. But today's not that day to do that, nor would it be appropriate for the court to direct that type of conduct, because that's something that you and your attorney can do at the appropriate stage.
Thank you for being kind.
So I took oranges to my daughter's freaking soccer game once. Anthony, my son, was like 2.5 years old, 3 years old maybe, right? My mother gave him an orange slice, and it had a seed in it, and he ate it, and he breathed it in, and it got caught in his lung. So there's my son. Terrifying. So I grab him by his ankle. And I'm hanging him upside down, and I'm pounding the back of his back to try to get him to expel this orange that's stuck in his lung. It's in his lung. He can't breathe. Okay? So while I'm holding him upside down, my kids are playing soccer. I say to my mom, take care of the girls. And I take Anthony and I throw him in the back of my car. No car seat, nothing. And I drive as fast as I can to the hospital. I get to the hospital. He's breathing, but he is barely breathing. I get to the hospital. No one even opens his mouth. They call right away for a different ambulance, to not like one of their regular ambulances, a different ambulance, to come and pick up my son. And I have to sit there and wait for this ambulance with my son barely breathing, and nobody's just opening his mouth. I'm like, can't you just get it out? Can't you look inside of his mouth at least? And I get it now. I think if they would have tried, they could have pushed it, and they would have completely obstructed him, and they would have rushed him into surgery or anything. But this ambulance takes us to, no, I'm sorry, I'm wrong. This ambulance takes my son to Hershey Medical Center, a great big, better specialist hospital, about 45 minutes away from the place that we are in. And I have to follow behind with my car. I get there, and I'm with my son. They have him in this crib type thing with big like plastic walls, and I'm sitting beside him, and he's cannot breathe. He cannot breathe. Okay. Well, the specialist isn't there, and doesn't come until the next morning. So my son it's all night long. I sat and listened to this. Well, my mom, when the soccer game was over, she came and dropped the girls off at Hershey Medical Center. I couldn't leave. I couldn't go anywhere. My son can't breathe. My girls had to sleep under his crib on the floor. The nurses gave them like one blanket to put down on the floor, and they slept on the floor in their soccer clothes. I remember I called my husband. I left Anthony for a few minutes. I went outside because I knew I was going to get loud. I mean, if you know, you know. You mean if you're gonna make a scene, don't do it in the hospital. So I didn't want to get kicked out of the hospital, so I went outside to call my husband. I'm like, you have to pick up your daughters. I need you to pick up your daughters. I need to be with Anthony right now. They need someone to watch them, feed them. They don't need to listen to this, what's going on. They don't need to be here right now. They need to be somewhere else, anywhere else. I need you to come and pick up your daughters. Yeah, I don't know why. I don't know why. She didn't just keep them. I don't know why. It doesn't matter. My husband says, oh, I I really, really can't. I have to work in the morning and it's really late. So those two girls slept under that crib that night with Anthony above them on the floor, with Anthony above them, barely breathing. And then the next morning, the doctor comes in. I don't know what kind of doctor he was. I don't remember. I was traumatized. He had this little long, like, it was flexible, okay, metal. It was metal, but it was flexible. And in the end, these little things came out. These little, like, prongs came out. Sort of like a claw. And he went in, and he grabbed them, and he put them in a little jar. It took minutes. It took just a few minutes. He just went in and grabbed them and put them in this. It wasn't like a glass jar. It was a little, I don't know what it's called. It was clear. You screw the top on. It was plastic. And he like hands it to me. Goes, here's what he had in his lung. Do you want it? I'm like, my son was finally breathing perfectly fine, acting like a clown. I'm like, there are no words to describe me that night, because I was there. I was just watching my son. That's it. That's all I could do is watch my son. Nobody barely even spoke to, like, no one spoke to me. They would come and they would check him every once in a while. Like every time he would finally fall asleep, they would come and check him and wake him up. And I would hear that. I don't know how he did it. I don't know. I can't 100% remember. I think there was a camera on it, but I don't know if I'm making that up. This was 20 years ago. I should have planted that orange tree. But, I mean, I think I remember a TV screen. But I don't remember. I had the two girls. I had the boy. I was just trying to figure out, is he going to live? So I don't remember how he did it. I just don't. I just know he came in. I remember seeing the flexible, I remember him bending it. And I remember seeing these little prongs come out at the end. And he was like pulling something or doing something to the other end. And that was it. That was it. I don't know if I ever slept again after that day, Martha. That day was so scary. Oh my gosh. Oh man. And my poor girls, they don't remember. They don't remember it at all. But they had to sit there and listen to that all night long. And I don't have no idea what they were thinking. I didn't ask them, what are you guys thinking? Are you scared? I'm sure I said things like, he's going to be fine. Look, we're at the hospital. Look at the doctors around. But still, Josh, I don't know if you can hear me or not, but you got grapes, and you got cotton candy grapes, which are seedless. So no one is going to practically die at your track meet today. Good job, Josh. Good job. All right. Back to court. We have 3 minutes and 40 seconds left.
So what I'm going to do out of this is formally just order a third evaluation, noting the inconsistencies in the two, being that they were opposing viewpoints, and then have the matter scheduled for a further status hearing. I'm going to set it for about 60 days out, Mr. Ariano, and then in the event that we've not had the evaluation scheduled, that may be continued. But at least the 60 days is kind of a time frame we'll be working and circulating around.
I do have one more question.
Let me get the date, Ms. Gaff, and then I'll turn to you for that question.
Okay.
I think, Mr. Ariano, you had scheduled some for May 14th or May 21st.
Yes.
Do you have a preference on that?
No preference, Your Honor. I think both dates are still, both dates are still open. Whatever works.
So I'll set it for May 14th as of now. That's at 9 a.m. That'll be for a status hearing. We may not have that hearing, Ms. Gaff, given that there may be the evaluation that's scheduled. But once we know more about when that's scheduled, we will either keep that date or move that date. So stay in contact with Mr. Ariano about those hearing dates. What was your question, ma'am?
Okay, so when a person thinks differently about certain subjects, you find it to be a sign of mental incompetency when someone doesn't think the same as other people because they think differently, that they're mentally incompetent for the ways they think, and it's biased opposed to the Freedom of Speech Act, and they're using our words against us when I don't do nothing to hurt nobody. And I'm just trying to understand why a person with a different thought process is deemed mentally incompetent.
She's got a point. She does. She has a valid point there. Except, like I said at the beginning of the stream, it's not about your thinking. It's if you understand what is going on in this courtroom. What is the duty of the judge? What is the duty of the jury? You know, that's what you have to understand. But she does have a point. When people think different than everybody else, people do think they're insane. Sometimes they kind of are, though.
Not everybody thinks the same.
Well, I want to note, Ms. Gaff, for the record, that I'm not really hearing a question in your statement. It's largely just either rhetorical question or an observation of yours, but I just don't really agree with what you're saying, in the sense that I don't think it's because of what you're stated here or viewing things differently. That's not why we are doing what we are doing right now. So I'm really not going to respond other than simply saying I appreciate the statement, but it's not necessarily a question that can be answered as of now.
Not everybody was made the same, sir. That's all I have to say. Just because they think differently doesn't deem them mentally incompetent.
I appreciate that, Ms. Gapp.
I do thank you for your precious time and your kindness.
Anything else that needs to be addressed, Mr. Ariano?
No, Your Honor. Thank you.
Mr. Langowski?
No, Your Honor.
May 14th at 9 as of now, and then wait to hear from Mr. Ariano and or that evaluator directly. Thank you, Ms. Gaff. You're free to go.
Have a beautiful day.
Here, Ms. Gaff.
Mary, you've been with me for 2 years. 2 years. You've been with me for so long, and it's so good to see you. All right, my son just texted me. I have to go pick him up. Hopefully he didn't eat any oranges tonight at work. I would like to just have a stress-free night for once. All right. Thank you for your precious time. Thank you for being kind, all of you. And I'll see some of you in six or 7 hours. All right. Thanks for coming out, guys. Thank you so much. I'll see you soon. Bye. I'm going to leave, so I'm going to stop the stream when I get home. So the stream's going to run a little extra long today with nothing. But I got work to do. I got to get moving, or my poor son will be out in the cold alone.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her style is classy. She's always guarantee